So basically, as it turns out then, it actually is the proper procedure to use the Parliamentary Papers Act 1840, Section 2. If you get prosecuted criminally or by civil action for proceedings that you're doing for petitioning Parliament, right? Or, publication of your material, or even persons who are doing it for you, right? Now, it only covers you for summary charges, though, but it's not. You're using the Act, and it's made it into law that you can use it for a specific purpose, but it's not privilege. Now, if you got indicted, if it was an indictment in the Crown Court for any charge criminally, you wouldn't be able to use that Act, right? So it's really for misdemeanours associated with going about petition campaigning, right? Or newspapers or anyone else like publishing things to do with Parliament, but also for Parliament itself when it's publishing its own proceedings and documents. But some of those proceedings and documents it's publishing are like the manuals that tell you what to do and to make use of them, right? And Parliament have been wrongly interpreting it for their own use only, and not for, as the title of Erskine May's book is, the law, privileges, proceedings and usage of Parliament, right? Now, if you get indicted, it's not misdemeanor, it's more serious, but, the thing is that you probably can rely on the 1688 Bill of Rights, but you're going to have to justify that, I suppose, but you're not defending yourself, still claiming privilege. There's still that petition for leave of court that they're required to hear the case, right? But if you use the Parliamentary Papers Act, you're just kind of like getting them to stop it. So they're going to hear your case when you present that. It's not defence, right? It's a claim through the Act. Now, when they apply for petition for leave of court from Parliament, that's when Parliament can give them petition to hear it or not. And they're still, I think you still can claim it, but then you're getting on to actually using the privilege itself and the actual claim of it, and going to the Bar of Parliament to claim it or to ask for support or backing up. You don't get the Parliamentary Papers Act. It's only useful in summary charges, which are misdemeanours. Like all those offences under the Met Police Act 1839, I think, all those are misdemeanours, like, placards down the pavement and all that type of stuff, stopping in the street, if you're obstructing the road, if you're delivering them, all those offences that you're protected from if they're misdemeanours, because it says that Act, you can use privileges in those Acts. It is one of the privileges of London anyway. Now, I didn't actually want to go on too much. So, in Section 2, it says you submit an affidavit with some sort of, evidence of your papers, which could be like a copy. You might need to show a copy of an advertisement or a flyer or something like that you produced or someone made for you, like printed flyers for you, right? Or the newspaper itself, right? As well as the affidavit. But remember, your original petition, when it's written out properly, is equal to an affidavit, surely, with the statement on the bottom of it, and, that in duty bound your petitioners shall, forever pray, etc., whatever, that is making it into a legal document and statement, right? And I think, in my opinion, you actually can you produce that itself, but how I've done it is, the thing is, I did an e-petition, and they've modernised e-petition, so it's not all laid out like the correct proper petition, right? And courts should know what e-petitions are, but the good thing about e-petitions is this: it's official, right? It's on the government website. So if that ain't something that Parliament's published and produced with you, it's yours, right? Then it's validity is solid because it actually is as official you can get, right? But can the courts recognise it as what it even is? if it's not in the original traditional form, because they're supposed to have, like, you know, the statement of truth, etc., duty, sworn in, and etc. at the bottom, and all the whole thing made out to actually know what it is, right? So this is what I've done, right? So this is the NC285 form, right? This is form N285, the affidavit template for the modern courts. There's 2 pages to it, right? There's the bottom part, which is the actual form, and the top part is just like the government advice for the form, right? So all you actually need to submit to the court, according to section 2, is the affidavit with the paper, right, to get it stayed or stopped. It doesn't actually say anything about any other procedure or proceeding. Now, when you normally have to make a representation to the court, if you're I don't know how lawyers do it, because I'm not a lawyer, but I've self-represented, and, you know, it's been received and everything. So you normally write it out like a representation. Look, right, let's take Lord Hanningfield's 6-page paper, for example, right? I mean, you've seen these court judgments when the court issue a judgment, you know, you can see how it's laid out, because it's like, you know, you just copy it, right? You know, it's got the court at the top and, you know, whatever versus Crown and the case number. And then you write out your points and number them and, you know, whatever. And then, you know, you stand at the bottom, put your statements of truth or oath in or whatever. But I don't think the normal court representation has it in, because, like, you know, even when Jeremy Johnson wrote his, he just puts Jeremy Johnson at the bottom. He doesn't actually put an oath in it. I think any documents which need to be sworn, like a witness statement or testimony, are done separately on a document like this, right? But in this affidavit, you can explain the claim as well as write the truth and facts in there, right? You're just really validating all your documents with it. I can't see how you would need, like, you know, a normal court form addressed to the court, you know, dear sirs and madams, with the case number, blah, 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 at the top, and then written out in numbered points, and then you attach an affidavit to it extra, when this affidavit form has you put all your case information in, name, address, everything that you would put in a normal court document, and then it says you put your numbered points in to explain it, right? How is that not, you know, a letter to the court anyway? So what I've done is all this top part here, I thought I'll just keep it nice and neat like this form is here. I mean, there's nothing stopping someone copying that affidavit form and putting it into their own PDF, right? If you want to, you know, and obviously you can write more than 1 page, right? When you fill this in, it expands the box. But to keep it neat, right, and tidy, and just to keep it simple, because it's not actually it's not a complicated claim. There are only, like, simple things you've got to prove, right, and show. Now, what I did is I deleted all this. I thought I'm going to leave it like it is, like this form, in the sense that it's just 2 pages in 1 PDF. I'm going to keep it as a PDF, and I'm going to keep it as 2 pages. But what I did is I deleted all this writing at the top, which is just the guide. And in that top part, I put my exhibits, right? I put, like, photographs and images of my exhibits and wrote, like, exhibit whatever it is, like ABCD or whatever. And I also put a little list of legislation that is relevant. And then in the bottom part, I filled it all in correctly and properly with, like, numbered points. And then at the end, I put the exhibits, explanation of the titles of the exhibits in relation to what I'd put in the top, right? And that was pretty much it. And I can't see how that is not adequate for that Section 2 claim. So, for example, if you had an advert in a newspaper, or if you were sending flyers out, then you would, like, put a photograph of them in this top part and, like, put Exhibit A or whatever. And you could actually even have, like, you know, your petition from the e-petitions website in there as well. And anything else, like another photograph or something you might need. Or, like, a link, like, and what I actually did is I actually when it comes to the basis behind it all, I just made a video for it, a video explainer, because it's a lot easier to explain it verbally than in writing. And I've even got actually more thorough, I've even got better explanations that I've come up with since. But I think it's the main point of revelation and insight that leads on to what I've got to now. So once you understand that thing, that, you know, the manuals of procedure in public business are a small, condensed version of the standing orders. And the standing orders didn't even have public petitions until after 1840. And it's clearly obvious that when they made the 1840 Act, after that, then you've got a rule standing order for public petitions presentation, right? But it obviously exists. And then you say, well, what about, you know, proceedings outside of Parliament, but they're in order to Parliament? Well, they're in the Tumultuous Petitioning Act that they exist in law, right? The existence of them soliciting petition campaigns in public, right? You know, which should cover newspapers as well. The word poster doesn't actually mean a piece of paper with ink on it, or a large sheet of paper with ink on it. The word poster means going about spreading information, right? It wasn't until later till the word poster in the dictionary actually decided that it can actually also mean actual physical material. It was actually the process and procedure of distributing information to persons, like whether or not it's like, you know, town crier or shouting or written down or in print, or it doesn't actually say what materials it has to be in. It's just like, and that meaning should apply through all law to do with elections as well. I mean, in the year 2000, it says, publish means to make available to the public or a section of the public in whatever form and whatever means. I'm like, hey, that's interesting. They've only just added that in the year 2000, right? But that's funny because that's pretty much exactly what poster meant, right? Someone going about making things available to the public or a section of the public in whatever form or whatever means, including by themselves, right? Talking about it, right? So the original word for poster in the dictionary all the way up to the start of the 1800s and the word publish now in modern terms for election law means pretty much the same thing. So when you're reading on the earlier election law before the year 2000 and it says, you know, posters, bills and flyers, etc., when it says poster, it's actually like, you know, the distributing of information in order to the public receive it. There's absolutely nothing in the dictionary. In fact, it's an additional term and a new term to say that it actually refers to some kind of, you know, papier substance with ink, right? So I don't actually believe that they actually could have tried to make out all through the 1980s and 1990s that in online digital advertisements and material and emails under Class E for elections, you know, didn't have to comply with the rules. Of course they did. You're posting material across the internet. It doesn't matter what form or means it's in. Under the word poster, it doesn't matter what form or means it's in, because it's like the doing word, not the objective word. It's not like physical objective substance to it. It's like more of an action doing word in a dictionary, right? And handbill is almost like, you know, giving it by, you pass it by hand. It's actually even referring to the fact that you pass it by hand or post it or stick it up, right? I mean, you could argue that handbill could be sign language, because like it says handbill, so like you use your hands, right? You know, it's like you could use sign language, right? You know, to say, well, you sign my petition, right? It's a handbill, right? You know, a petition, you know, and then if someone wants to sign it, right, you can shake your hand to agree. I don't know, whatever, something like that. But anyway, this is it. So this is, in fact, it also the thing with this, you put the courts in that are relevant. Well, you also will put Parliament in that court. You put the court that's bringing the charges, but then you can Parliament. And the thing is with this form, right? It says full names and occupation, right, of deponent. Well, if you are the defendant and the deponent, right, you actually, if you're petitioning, then you put you're occupied with petitioning at the time. So that's what you're doing, petitioner to Parliament's House of Commons in case number whatever. If you're doing e-petition or if it's on paper, then occupation would actually be petitioner or even canvasser, because you might not be a petition, but you're a publisher, like occupational publisher. So deponent, especially in Latin or Greek form, but actually the meaning, person who makes depository or affidavit under oath. So the defendant actually can be the deponent. So like it can be one and the same person, right? The defendant can be the deponent. But you're not necessarily defending yourself though anyway, because under modern law, really it's a right. Although I suppose that like if you're not actually using privilege, then it's not a right because you're using an act of law. But the act of law to stay proceedings, I don't really know, because the doctor certificate and form is something that like the Crown Prosecution and Probation can act on. It's not a defence. It's from a third party, right? It's impartial and it's like a certificate, and effectively so is your petition. And when you put this affidavit in, it's just affirming that the petition is correct and true. In fact, I've just found out that the doctor's notes are not even to the standard or quality of an affidavit, but yet, you get legal actions done on them and they're not even an affidavit. So the affidavit is actually a level up from the doctor's note anyway.